Welcome once again to Lehto's Law. Here's Steve Lehto.
Very interesting story out of Ohio, but up front I'm going to tell you I do not endorse or condone what the woman in the story did. So don't make comments about, Steve, I can't believe you're promoting this. You think what she did was right. No, I'm not saying what she did was right. I'm simply saying the underlying legal issue is important, and it's something I agree with on legal terms. I don't agree with what she did. So, pregnant mom can't be charged with drug possession, the Ohio Supreme Court rules, and the case could have broad implications according to the ACLU. Laura Bischoff wrote it for the Columbus Dispatch. When the woman gave birth, her baby boy tested positive for cocaine. She was then convicted of felony drug possession in Ohio's Seneca County. So they said, you are in possession of cocaine because your baby was born and tested positive after delivery. Therefore, the cocaine must have been in your system, which means that you were in possession of it. The Ohio Supreme Court on Thursday tossed out that conviction, saying the presence of cocaine in her system at the time she gave birth was not sufficient to bring drug possession charges. And here's the thing. Some states say it's illegal to possess illegal drugs the same way it's illegal to use them. And the question is, what does it mean to possess them, and what does it take to be convicted of possession? This will vary from state to state, but Ohio's Supreme Court got this right, and I'll explain why as I tell you. Meanwhile, the ACLU of Ohio, which filed an amicus brief in favor of the mother, said the ruling does have broad applications, but those are good. The Supreme Court decided once someone takes a drug and it's inside their body, they don't have control over it, so they don't possess it. That ruling is not limited to pregnant women and newborns. It would apply to anyone, says the attorney David Carey from the ACLU of Ohio. Now, the mother admitted that she used cocaine during her pregnancy a few times, but challenged her conviction on the basis that the state failed to prove venue because there was no evidence that she possessed the drug in Seneca County. And here's the thing. Under Ohio law, they not only have to prove that you did something, they got to prove where you did it, because that's where you've got to be put on trial. They can't find that you did a crime over here and put you on trial in a different county, for instance. They must put you on trial in the place that the crime occurred. So the question is, where did this crime occur? That's the whole point. Venue is key. Under the Ohio Constitution, the accused has a right to a speedy trial by an impartial jury, and this is the quote, of the county in which the offense is alleged to have been committed. Evidence of proper venue is required to sustain a conviction, according to the Ohio Supreme Court. And that's, by the way, that's common in many states. So that's why there's sometimes issues where a crime happens someplace and it's clear that a crime was committed, but no one knows where. And so, for instance, they find a body, and so somebody is going to be charged with murder. Where did the murder take place? Not necessarily where they found the body. And that's come up quite a bit as a defense in some cases. The prosecution argued that the positive drug test and the woman's residency in Seneca County during pregnancy and her admission to using the drug as well in Seneca County was the proper venue. But the defense countered that a person can't possess a controlled substance once it has been assimilated into that person's body. And it does boil down to what is meant by the phrase or the word possessed. So possession of the drug. The ACLU of Ohio argued in its brief that charging someone with drug possession because of the mere presence of drugs within their systems amounts to cruel and unusual punishment. Such charges would have a chilling effect on individuals who may be seeking medical care. Hospitals often screen newborns that show symptoms of drug withdrawal, and that's what happened in this particular case. So the attorney said the ACLU of Ohio is pleased with the ruling. If the prosecution had its way, a person could be found to possess a drug merely by having it in their system, regardless of where, when, and under what circumstances the drug was actually ingested. If that was the law, a person could take a substance in a place where it is legal to do so and could later be arrested in any county in Ohio simply for being there, for as long as the substance or its byproducts existed in their system. The court rightly saw that as an absurd result. The drug possession charges against the mother were no good, therefore this conviction was thrown out. Now, you might say, Steve, that's absurd. That's absurd. Well, there's a solution for this. A very, very simple solution. And that is you change the law. You have to either redefine possession, or there's a variety of ways to do this. And the reason I know this is that in Michigan, for many, many years, if they caught someone driving and they gave them a breathalyzer, and they blew over a certain amount, you'd get charged with operating under the influence, driving while intoxicated, whatever they called it at the time. They've changed that name a whole bunch of times. There were occasions where someone who's 20 years old gets pulled over, they blow a breathalyzer, and they blow it below the legal limit, but they've still got alcohol in their system. And the question then became, wait, what do we do? This person's been drinking. And so they used to charge those people with minor in possession, MIP, minor in possession. They'd say, you are in possession of alcohol because it is in your system. And I remember attorneys making the argument and some courts saying, you know something, possession, when most people talk about it, is the fact that you have it in your control. And it gets back to what the Ohio Supreme Court is saying here, that it's in your possession. If you want to, you can get rid of it. But the fact that it's in your body is not quite the same as possession in the most common sense of that word. And so I double-checked this, and Michigan has rewritten the statute. So if you go to the Secretary of State's office now in Michigan, it says, additionally, if you're under age 21, it is also against the law to drive with a bodily alcohol content of 0.02 or more, or with any presence of alcohol in your body. And then it says, except for that consumed at a generally recognized religious ceremony. That's the exemption. But you cannot drive a car with any presence of alcohol in your body. And the reason that that's written that way, notice, does not say the word possess or possession. And this was clearly drafted this way to make it clear that we're not going to just say that you're in possession under the possession rules, because we're not sure if possess means that in that sense, or it's understood to mean that. So instead, they just say it's, in essence, zero tolerance if you're underage. Alcohol is zero tolerance. And they're not saying that, possession. They're saying presence of alcohol in your body. Presence of alcohol. Now, obviously, the state of Ohio, if they want to, could rewrite their laws and say that it is unlawful to have these things in your system at any level. But they're probably going to get into a little bit of an issue as to how it got there, but that's neither here nor there, and also how accurate the tests are, okay? But the simple question is this. If Ohio has a law that says that you cannot possess something, okay, and you ingest it, and they later find out that it's in your system, and they charge you with possession because it is in your system, they can't do that, presumably because, number one, how do they prove how it got in your system, and when it got in your system, and where it got in your system? And they can't just charge you where they found you, because that's not necessarily where it got into your system in the first place. And possession generally means that you have something in your control that you decided to get into your possession, and theoretically you get out of your possession. I know you're saying, but Steve, the stuff in your system will eventually get out of your system. Yeah, I know. But the real issue here is what is meant by the word possession. So it's an interesting case. Again, I'm not condoning or endorsing what the woman did. I think it's horrible. But the legal issue, I believe, was ruled on correctly. So you can argue with me about that all day long. But please don't say, and I can't believe that you endorsed what that woman did. Because I didn't, and I don't, and I never will. So, interesting story out of Ohio. Vicky sent it to me. Laura Bischoff wrote it for the Columbus Dispatch. Pregnant mom can't be charged with drug possession. The Ohio Supreme Court rules. Case could have broad implications, say the ACLU, and it will have broad implications. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Life is too important to be taken seriously.